Mr. Galt, if you can have a seat there, please. We'll go on the record. This is People versus Richard Galt, file number 244943. The record should reflect Mr. Galt's presence here in the courtroom today, so I can have counsel put your appearances on.
Member Ryan Ziegler on behalf of the people.
Thank you, Honorable Gurmurthy, on behalf of Mr. Galt.
We're here today. Mr. Gurmurthy has filed a motion to withdraw as Mr. Galt's attorney. I guess one thing that affects the court's consideration here, I want to make sure the record is clear. Again, because I think there's a difference between Mr. Galt, you asking the court to appoint a different attorney for you, and Mr. Gurmurthy asking to withdraw from the case. So I want to make sure that we're clear on the record which of those two I'm dealing with.
Well, I'm going to ask that I withdraw from the matter. I think the other issue, which, and I'll leave it to the court's discretion. Mr. Galt is requesting another counsel. There's a process to that because the court no longer appoints counsel. Mr. Galt has been made aware of that. Mr. Galt has been made aware of that by Mr. Thompson, who is the indigent defense counsel.
Actually, before we go further, Mr. Thompson is, let me bring him in.
Okay, right. And I was just going to say Mr. Thompson wanted to attend this hearing as well.
Your Honor, I've filed several motions
Okay,
to the courts.
okay. And we'll talk about that in just a second. Mr. Thompson, are you able to hear me okay?
I can hear you. Thank you.
All right, we just got started with the hearing involving Mr. Galt. I asked for a clarification as to whether or not Mr. Galt was asking for different appointed counsel or whether Mr. Gurmurthy was asking to withdraw from the case, because those are two different considerations, or whether it's both. And so we've just begun that discussion just to bring you up to speed here. So Mr. Gurmurthy, you're asking to be withdrawn. Mr. Galt, are you asking for a different appointed counsel as well?
Yeah, well, Your Honor, first time I filed a motion, I was assigned, and this was back in July of 2024. I was assigned a new attorney because Mr. Gurmurthy was never actually. See, what happened is Mr. Seeger assigned himself to my case with a direct conflict of interest. You know, he represented the victim in the case, the victim's boyfriend, the victim's sister, the victim's sister's boyfriend, both of the victim's children. And it took me 5 months, 150 days before Mr. Seeger was willing to withdraw and acknowledge the conflict issue. So then, since there was a conflict issue, he handed me off to Mr. Thompson. Well, in the process, I got this letter here from Mr. Seeger. Says, I have enclosed a substitution of counsel. If you wish to have alternate counsel, this is your opportunity. And then again on this page, second page, I have enclosed a substitution of counsel. You may execute this form if you no longer wish me to be an attorney. You may. So this was with Michael Horwitz. I said, well, Mr. Seeger, Michael Horwitz, you share an office, so it's still a conflict issue. So he goes, okay, I'll see what I can do. He goes, you have anybody else that you would be interested in? I'm like, well, I talked to Patrick Cherry. He said he'd take the case if you'll appoint him. Mr. Seeger talked to Patrick Cherry. Patrick Cherry said that he wanted $350 an hour. So Mr. Seeger said, well, we ain't paying that. Okay, whatever. So he comes to me and he's like, I talked to Mr. Gurmurthy. He said he'd be willing to take your case. He goes, I'll send you substitution of counsel paperwork and you can sign and return to my office and we'll get Mr. Gurmurthy appointed to your case. So he sent me the substitution of counsel paperwork, which I have a copy of here. I got the original back at the cell. I never got a chance to sign it. It's never been signed to send it to me. It's never been ordered by a judge that Mr. Gurmurthy was even appointed to me as counsel. Okay, so I'm like, you know what? I'm not going to say nothing because if things go bad, I can always be like, Mr. Gurmurthy was never actually legally appointed to my case. So that's automatic grounds for an appeal, right?
Buckle up, guys. Today we are diving straight into a courtroom moment that sets the tone fast. The narrator wastes no time making it clear this case won't be polite or predictable. Then the judge calls the room to order. From the very first exchange, you can feel tension hanging in the air. This isn't just a routine hearing. It's the beginning of a clash between a defendant, his lawyer, and the court itself, with serious consequences already looming.
Refused to call any witnesses that I wanted him to call at the preliminary exam. So that's when I was like, you know what? Heck with this, I'm filing a motion to withdraw. Or filing a motion for substitution of attorney. So I filed a motion through Mr. Thompson because the case had to get handed to Crawford County because of the conflict issue out of Kalkaska. So I filed a motion and I was appointed a new attorney. Right here, for my August 1st, 6th court date is Shauna Sullivan. Right here, she's an insurance fraud investigative attorney out of Braintree, Massachusetts, that is allowed to practice law in Michigan. So I contact her and she's like, Mr. Galt, I'm not a criminal defense attorney. I'll contact the courts and get this straightened out. So she contacted the courts and I get a second notice for the same court date that says, this hearing will be held via Zoom. Defendant is lodged, notice resent with no change other than defendant's attorney is now Guramuthi. So I got appointed a new attorney and reassigned Mr. Guramuthi. So then we go to the court date on August 6th, Your Honor, Zoom, and I'm in Wexford Jail. And you're like, okay, Mr. Guramuthi, how's 90 days sound for continuance to file motions? And Mr. Guramuthi says, your judge, how about 120 days? And you were like, will that be enough time? And he's like, absolutely. So then on December 3rd, 14 months after I was arrested, no motion's been filed. I'm going to use your exact words, Your Honor. Mr. Guramuthi, you didn't show up today to court. That is unacceptable. Mr. Guramuthi, you didn't file your motions today. That is unacceptable. That's unacceptable. That's ineffective assistance of counsel. 14 months later, that one motion's been filed on my behalf, and you granted him 120 days to file motions. I've never even got a copy of the motions that were filed. He gave me a rough draft of these motions that had my case and Joe Cunningham's case mixed together. He came to the jail 2 days before court, the court date where the motions were filed on time, to do the corrections. He's like, I'll get you the corrected copies that I'm going to file with courts. I've still never seen a copy of the motions that were filed. I don't know what copies of motions were filed. So then I asked for transcripts, because I wanted transcripts, where you, Your Honor, stated, Mr. Guramuthi, you not showing up today is unacceptable. You not filing motions on time is unacceptable. I want them transcripts where you, Your Honor, said that, in case it comes to an appeal purpose. And then when we come to the motion hearing on January 24th, you're like, well, I'm not going to have you and Mr. Guramuthi both arguing motions. I said, all right, well, I'll let Mr. Guramuthi argue motions. So you're like, Mr. Guramuthi, do you have anything to say about arguing these motions? Mr. Guramuthi's like, no, Your Honor, I'm good. Well, if I'd have known he wasn't going to argue them, I would have argued them, Your Honor. You know what I'm saying? So there's another.
All right, guys, now we hit the first real layer of chaos. The court is trying to figure out a basic but critical question. Is the lawyer quitting, or is the defendant demanding a new one? That confusion matters, because each path has different legal consequences. As administrators get pulled in, the system starts to feel heavy and procedural, and you can sense the judge's patience being tested by how messy this situation already is.
Begged Guramuthi to file several motions, and I've got a list of the motions here. I even researched case laws for him for his motions, and he refuses to file motions. He refuses to he refuses to request body cam footage of the search in its entirety. I want officer activity logs. I've got proof with me today of Detective Nichols perjuring himself on the stand under oath. I've got right here.
Well, let's try to stay on the lawyer issue, because that's.
Oh, this is a lawyer issue. This is stuff I'm pursuing. And Mr.
Well, I'm not going to make any decisions about what police officers did or didn't testify to today. So tell me how that relates to your attorney issue.
Because I've asked Mr. Guramuthi to address this with Mr. Ziegler and be like, look, we can discredit your witnesses. We can work some kind of a deal, something. You know, I got my deal from Mr. Ziegler, Your Honor, was on 86 district paperwork with the wrong case number on it from the prosecutor. That was his deal. Another thing is I asked Mr. Gruber to file a motion, is you know what, Your Honor, felony complaints, citations, anything signed in those are made under oath, sworn to. You gotta be sworn to. I got a felony complaint right here with the paperwork filed from the prosecutor, signed with the complaining witness. It says I committed second-degree homicide on 10/30/2023 in Cold Springs Township. That's 2 days after the descendant was dead. I got a felony complaint right here that says the complaining witness has filed a sworn complaint in this court stating that on a date and location described above, contrary to the law, Mr. Galt in Cold Springs Township committed second-degree homicide on 10/30/23, 2 days after the descendant was dead. I've asked Mr. Guramusi to file motions to quash charges due to the fact that I was illegally arrested, illegally arraigned on a felony complaint and a felony warrant that contains false information. It was never signed and dated by anybody, the return and tabulation, where I was arrested. I've requested the SIDNET reports, which is an electronic report record for arrest, to find out who even served the arrest record, because I've never seen a felony warrant for 17 months. And I knew that the felony warrant was based off a felony complaint, which was inaccurate, and I couldn't do nothing without the actual felony warrant showing that I was illegally arraigned, illegally detained, and illegally arrested based on a complaint and a warrant with false information on it. Okay, this is where it gets good, Your Honor, and I brought this all to Mr. Gurumuti's attention. The uniform law citation that was filed to go with the complaint, right here, case number, says nothing about second-degree homicide. In fact, the one that says second-degree homicide was filed on 11/4, 6 days after the defendant was dead, 4 days after I was arraigned, by Sloan Kowalewski, stating that I committed second-degree homicide on 10/20.
All right, guys, this is where the defendant takes control of the room and unleashes a long, winding story. He lays out months of alleged conflicts, paperwork issues, and attorney swaps, painting himself as someone constantly wronged by the system. But as the story grows more complicated, it also raises doubts. To an outside observer, this starts sounding less like bad luck and more like a pattern, and the tension quietly builds.
2023. Warrants were issued until 11/1. That's false. That's lies in the uniform law citation. Now, this is where it gets good, Your Honor. It says right here, do not
All right,
write.
I'm not gonna, this isn't I'm not making any decisions on that. I'm not gonna dismiss your case today.
I'm not saying you are, but I need this
You're
all on
going into
record.
argument here on underlying issues. We're just dealing with the lawyer thing. So you think he should have filed motions on these things?
These are issues that I have brought to Mr. Gurumuti's attention, and he's failed to file any motions I've requested. And I want it on record that these are the issues that I've requested to file, the motions to be filed on.
Okay.
You know, these are major issues, Your Honor. They are. This is a murder case. There should be no topographical errors. There should be no misprints. There should be no false statements in felony complaints. There should be no false statements in warrants. Returns and tabulations should all be filed.
But I don't know whether they're false or not. I don't know whether they're wrong or not. And I don't know whether that would make any difference. So, again, what we're here on today is the attorney.
So basically what
We're
I'm
asking for different.
basically, there's been breakdown in attorney-client relationship. Mr. Gurumuti has filed a motion to withdraw. I filed a motion for substitution of counsel based on, and this is just a few of them, just a few of the things,
Yeah.
you
Okay.
know,
All right. I understand what you're saying.
you know, just, I don't know what to do, Your Honor. I'm looking at life in prison,
Well,
and I got a counsel that refuses to file a motion.
well, here's the thing, okay, and I'm gonna talk to Mr. Thompson, but one of the concerns I have is it's not gonna matter what attorney I appoint to you, because you're gonna find something wrong with any attorney
No,
that's
not.
appointed to you.
No, no.
Well, because you think that certain things have some significance, and if your lawyer tells you legally you don't have an argument here, or legally these are mistakes, but they don't affect the validity of the charges. You don't agree with that, and so you're gonna be back here again with your next lawyer who refuses to file motions that the lawyer thinks aren't warranted. And you're gonna be telling me the same thing. You understand what I'm saying?
Yeah.
Like you don't want to hear what your lawyer's saying because you disagree with it. And so you want me to keep appointing lawyers until you get one that agrees with you.
Well,
And that's not how this works. So that's my concern.
right, no, but.
When I listen to you talking, that's my concern is I could appoint 10 lawyers for you. And until one does what you want them to do, you're going to claim that they're not representing you effectively.
See, this is the
Because you're
thing,
not listening to what the lawyers are saying.
Mr. Garamusi doesn't even come and see me, Your Honor.
Okay, well, that's a different issue.
But this is the thing though, is the motions, Mr. Garamusi or whoever is appointed should be willing to file motions on these things.
Well, but that's
And
not
it's up to
true,
you to
though.
rule on them, Your Honor.
Lawyers don't just file everything that their client wants them to file. They have an obligation under the law to only file things that have legal merit. So
And
if you want him to file something, and in his judgment as an attorney, he doesn't think that it has legal merit, he or any other attorney that I appoint for you isn't going to file it. And what I'm hearing you tell me is that you want an attorney that's going to do everything that you want to do.
No.
That's not
No.
how it works. So that's my concern going forward with you and appointed counsel is that, again, I could go through attorney after attorney after attorney, and we never make it to trial because you can't find one that's going to argue things for you that no attorney thinks has legal merit.
All right, guys, here comes the first hard reality check. The judge cuts through the narrative and openly questions the defendant's motives, suggesting he may have stayed quiet on purpose to preserve appeal options. That accusation lands hard. The tone shifts from explanation to confrontation, and suddenly this isn't about paperwork anymore. It's about credibility, intent, and whether the court believes the defendant is acting in good faith at all.
I want to clear up some things that you said about the succession of attorneys and how we started and where we got. And Mr.
Just
Thompson,
could I
can you-
clarify before Mr.
Yes, Your Honor.
Charles? Because I can just add a couple of things that Mr. Galt indicated. I think that's important for the record. So Mr. Seeger, I don't know the conversation Mr. Galt and Mr. Seeger had. But when I was.
Well, and I don't want to have you and Mr. Thompson. He's the administrator. I want to hear what Mr. Thompson says. I'll give you a chance,
Okay.
Mr. Gurmurthy.
Thank you.
But I want to hear what Mr. Thompson has to say is going to clear this up or shed some light. So Mr. Thompson, can you tell me what information you have as the administrator of MIDC here?
Yes, Mr. Seeger contacted me. He indicated he was recusing himself from administering this case as well as being an attorney. I appointed Mr. Garamuthi, the court clerk. We've called and confirmed this with the court clerk. Made a typo on the P number, and that's how a lady named Miss Sullivan was identified on a court filing. But Mr. Garamuthi was appointed as attorney. Mr. Galt did request a new attorney through me. I turned him down. At one point, he did appeal. We had that administratively sent to Mr. Slough, the Otsego County Administrator, who issued a written decision also declining to appoint new counsel.
Okay, all right, thank you, Mr. Gurmurthy.
And that is where I was just getting at, Judge. So I don't know the conversations Mr. Galt and Mr. Seeger had. Mr. Seeger reached out to me about this matter as conflict for Kalkaska County. In those conversations, and Mr. Seeger may have had those conversations with Mr. Thompson previously or subsequently, I don't know. But one of the discussions was that since Mr. Seeger at the time was grieved by Mr. Galt, it made sense to not have Mr. Seeger on this case only administer the Kalkaska County MIDC administrative duties, and that should go to somebody else. And Mr. Thompson, being the Crawford County Administrator, only took over on this case to administer this matter. Whatever request and funding or other things that we've had have gone from Mr. Thompson. At one point, I did reach out to Mr. Thompson with Mr. Gall's request for new counsel, because as Mr. Gall indicated, some of the motions that he wanted me to file, I think were frivolous. They weren't with what the law would require. And again, there was, when Mr. Gall indicates that a motion to quash was not filed, the court heard arguments that was filed. When Mr. Gall says that motions that he wanted were not filed, we did challenge the search warrant and filed motions to suppress evidence. Those were heard. We had arguments here in court. So I think Mr. Galt is incorrect that no motions were filed. The motions that he wants, that I don't believe legally would have any authority to be filed, were not filed because they're not there. For example, Mr. Galt wants me to file a motion to discredit Detective Nichols. I think that gets done at trial. There's no motion to discredit him prior to a trial. So and again, the transcripts that Mr. Galt is requesting, he has those, because he has the preliminary exam transcripts. We had a full day, 8-hour preliminary exam in this court, and Mr. Galt was present. So again, some of the things that Mr. Galt indicates are not chronologically accurate.
All right, guys. This section digs into the heart of the defendant's complaint, ineffective assistance of counsel. He lists delays, missing motions, and lack of communication, framing them as career-ending failures by his attorney. The judge responds calmly but firmly, explaining that strategy isn't dictated by a client's wishes. This moment exposes the clash between legal reality and personal expectation, and it's where frustration on both sides becomes unmistakable.
Point did get involved because I received a subsequent letter from Mr. Slough because Mr. Galt had indicated that he wanted new counsel. I didn't know how Mr. Slough got involved, but I spoke with Mr. Slough and I indicated where my concerns were. But my breakdown comes in after all of those things were done, because certainly Mr. Galt didn't get what he wanted. He didn't get a new counsel. He was turned down by 2 administrators. And I haven't met Mr. Galt in the last 2 weeks, maybe 3 weeks, because I'm not going to take his verbal abuse. I'm not going to sit there and get called derogatory names. I'm not going to deal with his threats. And if I'm going to spend my time meeting with him, it's got to be a productive meeting, not one where I get yelled at, screamed at, called names, and threats being made.
Your Honor.
So at this point,
Wait a second, I'll give you a chance. It's his turn.
I'm
I
sorry.
listen to you. Go ahead.
so when those things happen, I'm not going to waste time and get treated that way. I'm not going to subject myself to that. Mr. Galt is, and I've told this to him, he's not my friend, he's not a family member, he's not a relative, and I'm under no obligation to take his verbal abuse because he doesn't get things done the way he wants or wants, new counsel, whatever his beef is. At one point, he was upset regarding something that happened with his house in landlord-tenant court. Again, there's a limit for me being a punching bag. I've got to deal with this case. This is where I am. But when it gets over that line, I'm not going to deal with Mr. Galt's abuse that way. I'm not going to subject myself to that. I have some self-worth. I'm going to hold myself to that. I've told Mr. Galt that, and Mr. Galt doesn't like that because I stand up to it. Leaving all of those things aside, Mr. Galt has filed a grievance. Mr. Galt has, my understanding, filed a grievance against Mr. Slough and Mr. Thompson.
Never filed one on Mr. Slough.
Mr. Galt indicated he's filed a grievance against Mr. Ziegler. So in the middle of a murder trial and prepping, I have to deal with grievances that have strict time constraints and requirements and turning over documents and other things that come with the own separate proceedings that I believe are frivolous, but I have to deal with those. And I've just reached a point where I've had a breakdown with Mr. Galt. And then I can't do my duty. My loyalty to Mr. Galt is just diminishing because of his actions, his conducts. It's not something that I've done or I've not done for him. I've got kites from Mr. Galt that he indicates he doesn't have discovery. He's got 2 sets of discoveries, 10,000 pages or so of copies that have been made and provided to him. So when he says he doesn't have those, they're untrue. And I just can't do these things and then get into a position where I have to deal with grievances and malpractice suits when those are, again, frivolous, that he's claiming that he's filed and he's done those things. So I've reached a point where there's a breakdown. I will admit to the court, the only things that Mr. Galt does not have is the search warrant body cams because I got them this morning from Mr. Ziegler. They're in my pocket. And again, certainly my intent is to download them to my office drive, so I have a copy. There's a laptop at the jail, and then Mr. Galt will have a copy to watch those there. So that's the only thing that he doesn't have, but he doesn't have those because we didn't have them until this morning when Mr. Ziegler handed them to me in court. Outside of that, I've had numerous emails with Mr. Ziegler, numerous phone calls. We've talked about a lot of other issues, litigating issues. At one point, Mr. Galt wanted me to set up some interview with the FBI. And in fact, made threats because I was not doing that, made threats towards me for not setting up the interview. And again, I indicated to Mr. Galt, I need to know what you're going to tell the FBI because you have certain rights. If you're going to incriminate yourself, I have to advise you and warn you of those rights. He wouldn't tell me. We did set up the interview. The interview was recorded. And again, Mr. Galt, that interview never went anywhere because Mr. Galt got angry and upset because it was being recorded. The FBI agent did Mirandize Mr. Galt, and that's not how Mr. Galt wanted to operate. So all of the things that Mr. Galt has done has, at least for me as an attorney at this point, led to a breakdown where I can't communicate with him. I can't represent his interest, and I refuse to go forward with this case and assist Mr. Galt any further because of what he's done with his verbal abuse, his threats, his derogatory attitude towards me, and I'm just refusing to put up with that, Judge.
All right, guys, this is where the defendant thinks he's found his golden ticket. He dives into dates, warrants, and alleged errors, believing technical mistakes should collapse the entire case. But the judge shuts that door quickly, explaining that police reports aren't evidence and errors don't automatically erase charges. It's a sobering moment, as the courtroom makes clear that courtroom law doesn't work the way internet research might suggest.